This is the third tutorial of a three-part series that covers GSARs. This tutorial will continue to address the key clauses in the deviation. Many suppliers or service providers seek to apply the law of their home state or country to govern a contract with the government to resolve any disputes that may arise. The GSAR deviation makes these clauses unenforceable. All disputes involving the federal government must be heard in either the U.S. Court of Federal Claims or U.S. District Court. Commercial supplier agreement terms that require the resolution of a dispute in a forum other than that expressly authorized by federal law are impermissible. CSAs may also include clauses that seek to allow equitable remedies, injunctive relief, and binding arbitration. The GSAR deviation renders these clauses unenforceable unless explicitly authorized by agency guidance or statute. Software publishers' CSAs may include a clause permitting them to unilaterally terminate the agreement for any material breach by the government. A software publisher's ability to unilaterally terminate a software license or maintenance agreement could result in mission failure. The GSAR deviation disallows commercial suppliers from unilaterally terminating or suspending a contract unless the supplies or services are generally withdrawn from the commercial market. The sole remedy for a contractual breach by the government must be pursued under the Contract Disputes Act. A software publisher's ability to unilaterally modify a software license could be improper or illegal for the government to accept. The GSAR deviation nullifies the vendor's right to unilaterally modify an agreement with the government. Typically, a CSA will contain a clause that allows assignment of that agreement by the vendor. Under the GSAR deviation, the contract, commercial supplier agreement, rights or obligations of either party may not be assigned or delegated without express government approval. Payment to a third-party financial institution may still be assigned by the vendor as expressly permitted under assignment of claims clauses. Confidentiality clauses protect information from being disclosed to third parties. The GSAR deviation ensures the government may share pricing or other important contract or license information internally and with authorized contractor support teams, even if a confidentiality clause says otherwise. Under the GSAR deviation, discrepancies found during an audit must comply with the invoicing procedures from the underlying contract. Disputed charges must be resolved through the Disputes Clause. Any audits requested by the commercial supplier or licensor will be performed at the supplier or licensor's expense. The current order of precedence contained in the Commercial Item Clause at FAR 52.212-4 potentially allows CSAs to supersede the terms of federal contracts, especially in those areas where federal law is implicated indirectly. The GSAR deviation moves addenda to this solicitation or contract, including any license agreements for computer software, to a lower order. The GSAR deviation uniformly addresses the most common unacceptable terms in a contract and streamlines the acquisition process. It also reduces the risk and minimizes costs to the government. Buyers are still encouraged to review and negotiate other terms to ensure the ordering activity's business needs are met. Thank you for viewing this tutorial. Please visit the DoD ESI website for more information and other videos in this series.